Another issue which law enforcement often faces is the hate speech issue. What is hate speech in the first place? It is basically any speech which would cause to show any hatred or any enmity or animosity against any in particular, or as in a community or religious people of any particular religious faith. And this kind of hate speech is definitely an offense, because it invokes public sentiment and could even lead to situations which go out of hand, like riots, and disturbs the public order. And this is covered basically by the IT Act also under section 66A, and IPC also deals with hate speech, and there are few sections which deal with it, 153 also. Now if you look at the hate speech, if you look at this particular aspect, that section 66A is currently being challenged by a case which is pending before the Supreme Court of India. In order to get clarity on what is the meaning and import, basically it is challenge the constitutionality of the particular provision, and the main purpose is also here to see and clarify what is the embed and import of the various terms which are used by the particular clause, like offensive messages or menacing character. Now what those really mean? So there would be better clarity once the guidelines are laid down by the court in this respect. Now if there is a particular message sent across which causes annoyance, intimidation, danger, inconvenience or obstruction, results in insult or injury or hatred or ill will, now those are crimes which will be constituting crimes under the IT Act as under hate speech. Now the offences such as these, they may even involve cyber terrorism if they are to the extent that they would hamper or damage the national integrity or sovereignty or public order. Therefore they are crimes which are very heinous. I mean, if you talk about section 66F, it is an offence which could even be punishable with a term of up to life imprisonment. Now waging war against government is punishable again, as I said, and 153A of the IPC again deals with the similar offences. If there is any kind of public disturbances being brought about, it is a punishable offence of imprisonment up to 3 years or fine or both. Therefore 121 of IPC, 153 or A of IPC, they all deal with such situations where there is public harmony which is disturbed because of hate speech, and such acts are again punishable offences. In case, I'd like you to note that in case this offence is committed in a place of worship, it is punishable with imprisonment which could extend up to 5 years and also liable for fine. Now in case of outraging the religious feelings of any class, if there is a caste or creed involved or particular religious feelings are hurt, then section 295A of the IPC makes the person liable for malicious acts and imposes punishment for a term of up to 3 years or fine or both. Now section 505, it gives a punishment for making statements which amount to public mischief or creating any sort of enmity between classes or distinction which is unfair, and the offence if it is committed in a place of worship also, that be covered. There in the normal cases up to 3 years of punishment is there, or fine or both, except 5 years in case it is committed in a place of worship. Then we talk about criminal conspiracy here. Criminal conspiracy is an offence under section 120A of the IPC. Now based on what is the object behind that, imprisonment is imposed and provided from a minimum of 6 months to life imprisonment or both, and fine also is possible in this considering the circumstances of any case. Next we have here is section 509 of the IPC. Now this is again a section which we see very often in cybercrime cases. particularly targeting women, where there is an act which is done either through email or fake website created, or a SMS, or a particular objectionable email which is there circulated, something which captures her pictures illegally, which are obscene in nature. Section 509 is mainly in the IPC, talks about insulting or outraging the modesty of a woman or intruding on her privacy, usually coupled with section 66E of the IT Act, and perhaps even 67 or 67A in case of a video clip. This could be involved under the IT Act, and under IPC 509 is normally used in tandem with these sections of the IT Act, where any kind of such information is published or transmitted without the consent of the person, containing the images of the person which are obscene in nature. Now, this is imprisonment of up to 3 years, and again fine of 2 lakhs or both, prescribed by the 66E of the IT Act. Now, defamation. This is another rampant problem we see under the current scenarios. I mean, a lot of times we see defamation, which used to be generally in the print media, is now also very rampant and found on the internet. Anyone can create any blog, any website, and try to put any information there against another person, which causes defamation. And without any substantial basis, if any false allegations are put on a person, it is a offence which is punishable by the law. Now, IT Act and again IPC sections are attracted. If we talk about section of the IPC, section 500 provides punishment of up to 2 years of imprisonment and fine, or both, for committing this offence. A person is actually guilty of defamation if he, either by words or even by spoken words orally or in writing, which are intended to be read, or by signs or by visible representation, he makes or publishes any imputation against a person with the intention to cause him harm, knowing that this will actually cause harm to the person's reputation. There are in fact a lot of exceptions to the sections 499 of the IPC, and the explanations are mainly of this nature, that in case a person, there is a person who is reporting a public, like a judicial proceeding, this is not going to amount to a defamation. If it is a fact which is being reported, substantiated by some evidence on that front, again it would not amount to defamation. If it's something for the public good, that is again not defamation. So there are various exceptions to the particular offence of defamation also. And please note that defamation is also possible against a deceased person, and it could be not only against a particular person, but also against a company or an association or a group of persons. Now, under the IT Act, the offence of defamation is dealt with under section 66A of the IT Act, punishable with a term of imprisonment up to 3 years or fine, or both. In this case, there was a famous case of Nirmaljit Singh Nirula versus Yashwant Sinha. The plaintiff had filed a suit for injunction asking the restraint orders against baras4media.com, which was a website which is a news portal, but it ran a malicious targeted attack against the plaintiff to make undue profits. And the court granted a conditional injunction in this case and restrained the defendants from licensing, writing or publishing against the plaintiff on their website through any media which causes any defamation to the plaintiff. That was an interim order. In another case, the Vyakti Vikas Kendra versus Jitendra Bagga, the Delhi High Court has dealt with a similar issue, wherein a suit for injunction, again a restraint order was passed against the defendant, restraining the defendants from publishing defamatory materials about His Holiness Sri Sri Ravi Shankar, who is the owner of the Art of Living Foundation. and then there was a successful interim order granted in that case as well. Now, the next issue which emerges here is the pornography. Now, when we talk about cyber pornography, section 67 of the IT Act along with 67A, which deals with sexually explicit content, section 67B, which prohibits child pornography, 66E dealing with invasion of privacy in the case of MMS clips, for instance, other main sections involved in this area. Section 292 of the IPC is also attracted, which deals with similar situations where a book, a pamphlet or a paper or a writing, a painting or any object which is deemed to be obscene, if it is obscene in nature, it is something which is punishable and is prohibited. Section 293 prohibits the selling of distribution or exhibition of any of such products or objects to any person under the age of 20, and these acts are punishable with imprisonment for a term up to 3 years and fine which extends to about 2,000 rupees. Now, in Tamil Nadu versus Suhas Kati's case, the accused had actually posted obscene messages about a divorcee woman in a Yahoo message group, which led to filing of the complaint, and FIR was filed, and later on after prosecution, a sentence of 2 years of imprisonment was placed on conviction. Another case is the Dr. Katari Sunil Kumar versus Hemilalali. Here a criminal petition for quashing was filed by the accused under section 482. Again, questions of the use of 509 and 67 of the IT Act were involved, and the court rejected the criminal petition because the electronic evidence found was indicating that the accused had sent in fact the obscene messages to the complainant using his laptop. Now, that was tracked using the IP address tracking mode, and that was found that these messages did go from his system.